Hi everyone, I'm Matt Dunn, the CEO of the Queensland Law Society, and before our upcoming AML seminar, we thought we would answer some of the burning questions that we might be covering at the event and let you know where things are up to. Currently the bill is passed the lower house in Parliament and it's in the Senate. There's a Senate committee inquiry that's returning a report on the 13th of November, and we're expecting the bill to go through the Parliament by the end of November. But let's have a look at some of your burning questions. Let's dive in. What is money laundering and why is it a concern for businesses? Well, money laundering is about getting money that's the proceeds of crime and putting it into the legitimate financial system. It's about placement, it's about layering, and it's about washing. So what it's about doing is finding a way to break the connection between the criminal activity that created the profit or the money and the use of that money in the system. And so often this is done through the banking system, through casinos, in other jurisdictions, in lawyers' firms and offices, unwittingly so, to be able to put an intermediary between the thing that generated the illegal money and the use of the money down the track. And so this whole regime is about trying to make it really difficult to get that illegitimate money into the legitimate financial system. Next question. What are the key components of an effective AML program? Well, I just happen to have the components of an effective AML program here with me at the moment. The key parts of an effective AML program are measures in place to do a risk rating of clients and transactions that fall within the scope of the regime, and procedures and policies in place to be able to know the client, know where the funds are coming from, and to be able to understand the nature of the transaction and the risk that it presents, that there is money laundering involved in that transaction. And an effective program also has other safeguards in it, like staff training and procedures for oversight and reporting. An officer who's in charge of the AML compliance for an organisation, and a new thing which is in the bill, that the governance organisation, the board or the boss of a particular legal practice has approved and is across the detail of the AML program. So there's a lot of moving parts in that, and it's quite a big thing for us to cover, but we'll do more of that later on. Next question. What are the legal obligations for reporting suspicious transactions? That is a good one. So under the bill, there's an obligation it's proposing that legal practitioners would report to AUSTRAC a suspicious matter report with respect to transactions. So if a legal practitioner feels that the transaction that they're involved with reaches that threshold of being suspicious, there's a positive obligation to make a decision about reporting and to report to AUSTRAC within a period of time. And that might be as little as up to 5 days. And that gets a little complicated for legal practitioners because we have duties of confidence and we have legal professional privilege that flows to the client in circumstances. And so there are some interesting balancing that has to be done about privilege and confidentiality. The bill's currently saying that if the matters that are in relation to the transaction are subject to privilege, they don't have to be reported. But if they are merely confidential, they will have to be reported. And so there's some really interesting decisions for legal practitioners to have to make about when they have to report and what they have to report. And this has been one of the key things that the QLS, the Law Council, and all of the legal stakeholders have been the most concerned about and lobbied about in the process. And that's another area that we'll really be going into in the program.